brother down with Shizzywhiznut.
Good morning, good evening, good day. How are you doing? Yes, the judge's order did come in, and we have it, and a new open letter. Stay tuned for that. Order. And this right here, of course, is filed United States District Court for the Northern District of Florida, Gainesville Division. Order. This matter was scheduled for a show cause hearing on April 3rd, 2025. Prior to the hearing, the court notified counsel for both parties that the following issues would be addressed at the hearing. 1, plaintiff's motion for sanctions, whether defendant's counsel pro hoc VJ status would be revoked, and 3, whether counsel for both parties should be sanctioned for their filing of specific motions that were frivolous. Docs 96, 98, and 118. Well, paradoxically, defendant's counsel failed to appear at the hearing that was scheduled in part for him to explain why he should not be sanctioned for his unprofessional conduct. The hearing was noticed on March 14th, 2025, and defendant's counsel was clearly aware of his obligation to attend the hearing. Indeed, the day before the hearing, defendant's counsel filed a notice informing the court of his decision not to attend the hearing. Doc 124. The court issued an order shortly thereafter, making clear that the hearing would go forward and that defendant's counsel was expected to attend. Doc 125. Less than an hour before the hearing was scheduled to begin, defendant's counsel filed a notice of withdrawal as counsel. Doc 126. The mere filing of that notice, of course, did not relieve defendant's counsel of his obligation to appear at the scheduled hearing. See subnote 1. Under the local rules, an attorney may not withdraw without permission from the court unless the client has another attorney of record who intends to continue in the case. See the local rules. Defendants do not have another attorney of record in this case. Therefore, defendant's counsel cannot withdraw unless given permission by the court. Such permission has not been granted. Nonetheless, defendant's counsel failed to appear. The hearing went forward regarding plaintiff's counsel should be sanctioned under Rule 11 for filing Docs 85 and 86. After hearing from plaintiff's counsel, the court thoroughly explained on the record that Docs 85 and 86 warranted sanctions because they were filed without sufficient legal and factual basis. The court explained that it believed an appropriate sanction would be $2,000 per filing for a total of $4,000. Thus, under Rule 11C4 and the court's inherent authority, the court orders plaintiff's counsel to pay $4,000 as monetary sanction. District Court for the Northern District of Florida. The $4,000 is due immediately and shall be paid to the clerk of the U.S. District Court for Northern District of Florida, as mentioned above. Defendant's counsel failed to appear at the hearing scheduled for April 3rd, 2025 at 1 p.m. The court hereby orders defendant's counsel to show cause as to why the court should not exercise its inherent authority and sanction him for failing to appear. See the following filings, or these would be old court cases, explaining that before issuing sanctions under its inherent authority, a court is required to allow an attorney the opportunity to respond orally or in writing. The show cause response is due by 5 p.m. on Wednesday, April 9th, 2025. So ordered this 4th day of April 2025. So he has 5 days to come with a good reason why he doesn't believe that he should be sanctioned by the court. The court has made it very clear, Bubbles, where your time of playing around is done. But I know why you guys came here. I know why you decided to click on this wonderful video. It wasn't because of this the judge handing down the sanctions, it was because you wanted a beautiful letter. Well, I do have that letter for you. Give me just a couple of seconds, give you a little intro, and we will come buckled up, strapped in, get ready. The letter is coming.
It is about time. Let's break this mother down. With Shizzywhiznut.
An open letter to BBB. The judge just started the fire and you're the kindling. Filed under court isn't a safe space, Bruce. Dear BBB, let's not pretend anymore. You didn't just lose control of this case, you detonated your credibility. Tried to moonwalk off the docket and hope the federal court would just forget everything you left smoldering behind. Well, it didn't. Because as of today, officially and on the record, the gavel came down. Randy Shockett, the plaintiff's attorney, just got slapped with $4,000 in Rule 11 sanctions for filing 2 motions that were, in Judge Bolitho's words, factually and legally bankrupt. That's $2,000 per motion, a pretty steep price for dumb paperwork, and Shockett at least had the decency to show up and take his lumps. You? Well, now let's think about you. Because unlike Randy, who showed up, took his beating like a man, probably limped back to his inbox rethinking his life choices, you ran. You filed a cascade of overwrought, redundant, gaslit, drenched motions. You flooded the court with acronyms and self-praise. You accused a federal judge of bias, misconduct, selective enforcement, and somehow being a secret fan of YouTube drama. And when the court told you to show up and explain yourself in person, you dropped a notice of withdrawal. Less than an hour before the hearing, like a petulant child flipping the game of board after losing. Well, you claimed extraordinary circumstances. You said you were afraid. You talked about family obligations, plane tickets, rotator cuffs, dead relatives, a high school band rehearsals. Because, Bruce, you didn't just run. You fled behind a tissue of excuses so thin the judge didn't even pretend to entertain them. Instead, he turned his attention to the real issue. Why you, the architect of months of procedural chaos, shouldn't be sanctioned into the earth's crust. Let's do some math, shall we? If $4,000 is the punishment for 2 garbage filings, what do you think your dozens of duplicative, rage-baiting, and bad faith pleadings are worth? Because unlike Randy, whose motions were just weak, yours were toxic, laden with attacks on the court, lies about opposing counsel, and layered with that now infamous playbook, protract the litigation and multiplying something about proceedings or weaponizing the docket. You wrote an acronym for it, Bruce. You called it Polymob. You even tried to make it a brand, but the only thing you're branding now is your legacy as a serial abuser of judicial process. The judge, he's already heard your excuses. He read your I'm scared filings. He rolled his eyes at your band practice and rotator cuff novella. He saw you cash out of this case while trying to crawl under the table before the check came, and now he is loading the cannon. You're easily looking at $10,000 plus minimum. Because here's what you still don't get, Bruce. The court isn't angry that you lost. The court is furious that you turned a federal litigation into a personal pity parade. You mocked the process. You lied about your availability. You treated rules like suggestions and filings like Reddit threads. And now that you've withdrawn unlawfully, by the way, still needs court approval, your only remaining contribution to this case is a sanctions bill that's about to slap harder than your entire legal career. You wanted content, Bruce. You wanted headlines. Well, congratulations. You are now officially the man who couldn't even face his own hearing, but may still set a courtroom record for the most fines incurred without ever stepping his happy ass inside. So here's your big moment, BBB. The judge just offered you a final chance to show cause, to explain why you should be fined into oblivion, to justify why abandoning your clients, ducking the court, and treating this like a live-action Tumblr thread that doesn't deserve public reckoning. You better come up with something good, because your GoFundMe donors already feel a little scammed. Your clients are lawyerless, and this judge, he's just holding it. He's not just holding the gavel anymore. Oh no, he's holding the receipt. And just so we're clear, we're not off the woods, not even close, because while you're busy dodging accountability in this case, let's not forget you're still a named defendant in Jeremy Hale's second defamation lawsuit. Same jurisdiction, same judge, same facts, just with more clients. And now you're trying to walk away from both like none of it ever happened. You don't get to play the victim when you're the only thing you're a victim of is your own damn mouth. You begged for money online. You told donors this case was life or death. You publicly swore you were in it until the end. You cast yourself as the savior, the only thing standing between justice and tyranny. And when the pressure hit, oh shit, you just cashed out and bailed out. You defrauded your donors. You abandoned your clients. You disrespected the court. Now you're writing filings like you're the one being wronged. You're not the victim, Bruce. You're the villain in a story you thought you were directing. And that $4,000 fine you watched fall on Randy, that was just the first domino. Because you still have to answer for failing to appear at a hearing where you're ordered to attend, filing 4 duplicative attorney's fees motions for pure spite, filing a false withdrawal without leave of court, weaponizing accusations against the judge and opposing counsel, misusing the court to air YouTube conspiracies and score pity clicks. All of that, every line, every wasted page, every insult wrapped in legalese is going to cost you in dollars, in dignity, in discipline. And don't think for a second that this is about fines. Your pro hoc VJ status, oh, it's already dangling by a thread, brother. You're standing with the Florida bar about to be tested. Your future is an internet lawyer for hire, dead on arrival. And if you think the judge won't go nuclear just because you pretended to quit, you've clearly never read an order with your name in the caption, because today's ruling wasn't a conclusion. It was a prelude. The judge just orders you to respond by April 9th to show just cause why he shouldn't sanction your happy ass for no showing the very hearing that you made necessary. That is not an invitation. That's the court laying out the carpet to crush you under it. So now, with the spotlight squarely on the back of your sweaty little forehead, the only question left is, what excuse will you use next, Bruce? Because the whole world saw through the last 10. Sincerely, Shizzywhiznut, activist of the cowardice, archivist of the cowardice, unlicensed court watcher, still not a lawyer, still more honest than you, and still standing all alone at the bus stop with his Velcro shoes. The world's coming down on you. And you better get your act together, because it's coming. See you soon. Make sure you hit that like and subscribe. If you enjoyed this content and you want to see more of it, man, subscribe to it. Yeah, you got nothing to lose. For less than a Starbucks coffee, you too can become a member of this channel and enjoy all the perks that come along with it. Have a good one.
It is about time. Let's break this mother down.